Hi everyone, I am Brian Dolan with the law firm Pepper Hamilton, and today I'm joined by Pepper partners Hannah McPhelin and Justin Weber. Today's podcast will focus on issues regarding commercial real estate leasing. It will provide a practical guidance on issues that are arising on a daily basis and issues that parties to a commercial lease should be anticipating. We will first explore what is currently occurring in the marketplace, what legal issues tenants and landlords are raising in light of COVID-19, and the framework for examining these issues and practical ways to approach these situations. We will also focus on what issues parties should be anticipating and how the current situation will influence provisions in new leases that are being drafted. Hannah and Justin, we have a lot to cover. Let's get started. Hannah, let's start with you. Can you describe what you are seeing in the leasing market right now?
Sure. Hi, everyone. We're seeing a lot of different things and a lot of flux, as you might imagine. I think one of the first things that we're seeing is a lot of uncertainty on new deals, and some of that is due to practical considerations. Very difficult to tour new space in states that have shutdown orders because you're not permitted to do so. A FaceTime, inspection or tour of a space is fine, but it doesn't really replace being able to be in there and figure out whether it'll work for your business. There's also a lot of uncertainty as to when construction can start again. For almost every new deal, unless you have plug-and-play space, either the landlord or the tenant is going to need to do some type of build-out to the space, and nobody knows when construction can actually start, and then also whether there will be additional delays in the construction process due to social distancing measures or other measures that the construction companies will need to put into effect to keep their workers safe. So it's very difficult to draft around that kind of uncertainty. So I think we're going to start to see more information on it in the next couple of weeks, and that really will inform how those new deals proceed. The second thing that we're seeing is a lot of tenants requesting rent relief, and this has been all over the news, so I'm sure you've probably read about it. Very early on, sometimes even before the shutdown orders, tenants were making requests to landlords to abate rent for some period of time. I think the retail and office tenants, but mostly retail, were first out of the gate, and as soon as the shutdown orders started, that really sped up these requests. There have been a lot of different approaches that we're seeing landlords and tenants take. We're seeing some tenants say they're not paying rent, period. We're seeing some landlords say you have to pay rent, period. Neither of those, I think, is helping anybody out at all. We're also seeing a lot of middle ground. So some type of short rent abatement, I would say anywhere from 2 to 5 months, sometimes a partial abatement. Tenant will pay 25 to 50% of its monthly rent for a couple of months. There's usually some type of payback. So it might be a lump sum that the landlord gets later this year or sometime next year, or the rent that's abated might get amortized over the rest of the remaining term, or in some instances, the term of the lease will actually get extended for the period of the rent abatement. So I think there are a lot of ways to tackle this. It's very much like a case-by-case basis in terms of where the landlord is and where the tenant is and where the tenant's business is. The sort of elephant in the room that you should be thinking about, though, too, is the landlord's lender. Some of this and what structures the landlord could agree to are going to be dictated by where they are with their lender and whether their lender is able to give the landlord some relief as well.
Thanks, Hannah. There's a lot of variables there. Justin, let's go to you. What is the framework for examining these issues, and what legal issues do you see parties raising?
Yeah. So as Hannah mentioned, we're seeing a lot of correspondence back and forth between landlords and tenants, and have been for the past couple of weeks. Most of the issues that we're seeing involve impracticability, impossibility, or frustration of purpose, as well as assertions of force majeure. And I know there's an entire podcast that Pepper and Troutman did on force majeure issues, so I won't get into those in great detail, but I did want to highlight that it's really important when you're examining these issues, either from the landlord or the tenant side, to start with the terms of the lease. The lease terms are provide the parameters that the parties have agreed to control their own destiny. And so starting with the actual language of the lease is always the starting point. The issues that we see raised by mostly tenants are frustration of purpose and impossibility or impracticability. And I'll touch on those very briefly. With respecting practicability, parties are raising that to excuse performance or to attempt to obtain some form of rent abatement. Impracticability, and that's really the modern standard. It varies by jurisdiction, but impossibility is an older historical standard, and impracticability is used now in many jurisdictions. Impracticability focuses on whether there's been an unexpected occurrence of an intervening act. And that act had to be of such a character that its non-occurrence was a basic assumption of the agreement between the parties. And the occurrence of that intervening act has made the performance impossible, or at least substantially or commercially impracticable. It is a very highly fact-specific test and analysis, and so it needs to be examined in light of not only the language of the lease that's involved, but also the factual circumstances that present themselves. The other doctrine that we see parties raising is frustration of purpose. And frustration of purpose differs from impossibility or impracticability because it doesn't have to be that the performance is impossible or impracticable. It merely is that the purpose has been frustrated. The typical law school cases on that concept deal with coronation. So there's a parade, there's a rental of space to view the coronation event, and the coronation is canceled. The purpose has been frustrated. It won't come to fruition, and it was a basic underlying purpose of the contract. How that plays out in lease context is if the lease has a very specific purpose that has been identified. If, for instance, the lease provides for a specific purpose that is now prohibited from operating by a government closure order, the tenant will have a argument that the purpose of the lease has been frustrated. And that's an issue that we're seeing parties raise quite frequently. Again, though, I think the starting point that everybody needs to keep in mind is looking at the language of the lease and then using the common law principles to fill in the edges around it or provide guidance where the lease may be silent on those obligations.
So what practical aspects should clients consider as they review their leasehold interests and determine the positions that they may take?
Yeah, Hannah mentioned a variety of those, and also that we're seeing landlords and tenants take practical approaches trying to figure out their way through the pandemic. I think that there are very few issues in this circumstance that don't have a practical solution. And what we like to advise our clients to do is to take a long view. Sitting here in week 4 or 5 of the pandemic, it feels like it may continue forever, and it won't. And so stepping back and taking the long-term view. If you're on the lessee's side, the space was operationally important for you at one point in time, and it may continue to be important again in the future. So you want to be careful that you don't take an aggressive position that results in a default. And if you're not successful in defending that default, you may have your lease terminated. And how are you going to operate after the pandemic passes if the lease is terminated? So really looking carefully at the value or the long-term lease value and the long-term value of your space. From the lessor's perspective, what's the length of term that's left on the lease? And where is the long-term value in the lease? Is it possible to, as Hannah mentioned, agree to an abatement or a partial abatement, amortize the rent over a period of additional months to work with the tenant to hopefully get past the time of tight cash flow, but still realize the benefits of the lease long-term? Also, as a lessor, I think it's important to be consistent and to develop a policy, especially if you are getting multiple requests from tenants for an abatement or another type of remedy to lessen their hardship. As I said, these are always case-by-case, lease-by-lease analysis specific, but it's important to have a policy, a way in which you apply a rent abatement or respond to the client request or tenant request for information. I also believe it's helpful to be proactive and to reach out. Many times, if the tenant is a small business, They might not be aware of all of the types of governmental assistance that are available through the stimulus bill or that may become available. And so providing them resources may help them to help their cash flow, which will ultimately help you. I also think it's important to keep in mind from a practical perspective the communications that you are generating and how they are going to look if you can't reach some type of resolution or work it out practically and you have to be in court. Now, how do you want to appear before a fact finder? Do you want to be the party who was inflexible and not willing to bend during the time of a pandemic or to reach a practical solution? And so keep in mind that if you can't reach a resolution, how are you going to appear as the matter continues and progresses? And always seek to take the high road and to take that ground for yourself. I think that it will play out better in the long run, especially if the case has to go to litigation.
And Justin, we're seeing a lot of landlords who do respond to tenant requests or do a proactive reach out with a standard list of documentation that they want from the tenant, including, various financial information, projections, things like that, to the extent any of us can project at this point. So I think those approaches by landlords are, have been received very well, and often they're accompanied by a list of those, various programs that the tenant may be eligible for in order to get that information in the right hands. So I think that's helpful for both parties.
Thanks, Justin. Thanks, Hannah. Hannah, let's stay with you. Justin mentioned this. The situation will end at some point. What issues do you see arising as the economy begins to reopen and tenants begin to reoccupy their space?
Yeah, we're really turning toward this now, which, as everybody starts to talk about reopening, but really rethinking through what all of this lease space will look like and how it will be used, because things have definitely changed. So I think there are a lot of measures that will need to be put in place. Some examples of the things that we're hearing about and that are being discussed are, what type of cleaning and disinfecting needs to happen before all the occupants come back, but then also on a regular basis. We imagine that our typical cleaning specs are definitely going to be enhanced and changed, most likely in connection with CDC guidance and things like that. But that will, require some changes on the part of landlords, possibly tenants if they're doing it, and also janitorial service providers. Requirements for entry into a building, especially if we're talking about a multi-tenant building, such as taking temperatures, providing masks. When do those things have to happen? Who's responsible for doing them or providing them, and who pays for it? One could imagine that we're going to see some changes to CAM and operating expense sections going forward, or at least in new leases, to try to address these type of measures. As I would guess, if the landlord's responsible, they're going to look to pass at least some of those costs through. But I think all of that will have to be worked out. And then, social distancing guidelines, creating this 6-foot office, as it's being called in some places, trying to figure out how people move around the office and interact with one another while maintaining, an appropriate distance and keeping everybody safe. I'll note several of the large brokerage firms have really interesting ideas on how to do this. I know I've seen things from Cushman and CBRE that have some good ideas and help you kind of rethink and reimagine how that space is going to be used. One of the things I'm really curious about is, before all this happened, we were seeing a trend in office space to less square footage per person, and now I'm wondering if we're going to see it swing back to more, although you could also have more people working remotely, so maybe that will offset it. So it's just sort of an interesting time, and I'm curious to see what changes are coming.
I think picking up on something that Hannah mentioned, it's important to think about as you are negotiating or attempting to work out a practical solution. Hannah mentioned about social distancing guidelines. And I know that in some of the phased approaches to reopening the economy, I've seen references to reducing the occupancy limits or prohibiting or making a new occupancy limit, which is 1/2 of what the previous occupancy limit was. But I think it's important as you begin to work out a practical solution between a landlord and a tenant to think about what happens in the future in a month from now if the capacity of the building, let's assume it's a restaurant, is cut in half. How does that impact the operations? And so as you're negotiating, I think just be mindful that we aren't sure how it's going to look when we come out of it. So even if the business and commence operations again, those operations may not be at the same extent that they were before we went into the pandemic, and it may take a little bit of time to get there.
So continuing to look to the future, as new leases are being drafted, are there provisions that you would suggest parties pay careful attention to right now?
Yeah, I don't think that we'll ever draft a force majeure provision exactly the same way again. So I think that would be the first thing that was the first thing we thought about when this happened, and I think it will be something that is a work in progress for a long time. I think in general, the force majeure provisions will be much more specific, more to follow sort of litigation guidance. They'll definitely specifically name pandemics, but I think also other events. I think we'll all put our collective heads together and try to think of all of the, sort of terrible things we never thought would come to pass, and that we need to build into these provisions and actually name. I think also they'll be shaped by the litigation around these issues that we're really just starting to see. So I think that's going to go on for quite some time. But I do expect that we'll be drafting and redrafting based on how the courts decide a number of these lease issues that will inevitably be decided by the courts. I also think that we'll see new lease provisions, and we're already putting these in new leases for certain clients, describing what happens in the event space can't be used due to a government shutdown order. And in some cases, that will include a partial or full rent abatement for tenants, or those tenants who can negotiate that. I think these provisions are going to be heavily negotiated. They're not particularly complex at this point, but I can certainly see where they would get to that point, as we move on and have a little bit more time in this sort of new normal and figure out, how everybody is going to occupy the space and what we might want to ask for if this happens again.
I think one of the other things that we may see, at least from a tenant perspective, is wanting to identify the purpose of the lease, maybe more narrow than we did in the past, because of the doctrine of frustration of purpose and the renewed focus on it. So a party may want to, if it's using the location for a specific type of restaurant, may want to identify that very specifically in the lease. And if it's not able to do that, it may have some other types of remedies. So it will be interesting to see whether the interplay between landlords and tenants changes as far as the specificity in which the purpose of the lease is identified.
I think that would be an interesting twist in negotiations, because traditionally the landlord is always trying to narrow the purpose and the tenant is trying to broaden it. And I think we may see that flip, especially depending on some of the litigation that comes out of this.
In these uncertain times, this was definitely a lot of helpful information from both of you. So I wanted to thank you for our listeners. Hannah and Justin, appreciate your time today.
Thank you.
Thank you.
For our listeners, if you have any further questions, please feel free to contact Hannah or Justin, or visit our COVID-19 Resource Center at covid19.pepperlaw.com.